Well, I'm Emily Marks. I'm the Chief United States District Judge here in the Middle District of Alabama, and I have the privilege of interviewing one of our longest serving United States Magistrate judges, who also happens to be my father. So good morning, Dad.
Good morning, Emily.
You have been a United States Magistrate Judge in the Middle District of Alabama since 1987.
1987, May 1, 1987.
And you have served continuously here
Yes.
during that time. You've seen a lot of changes, so we want to just get your thoughts looking back on 35 years
right.
almost of your service to the federal court. But just some background, you have 3 daughters.
3 daughters.
I'm the middle.
You're the middle.
And
You were born when I was in law school.
that's right. I'm a native of Tuscaloosa.
You are, that's right.
And then obviously Christine is your
Is the
oldest and is a lawyer in New Orleans and lives in New Orleans. And then my younger sister,
Is
Amy.
and she's a social worker. She's the only one of you 3 who, went the straight and narrow path rather than going into law.
That's right. She's saving our souls.
That's right.
And then Mom passed away in 2007 from breast
After a
cancer.
5-year fight with breast cancer.
And then after that, you found and married Hendon Blaylock
Yes.
in 2009.
And we have a blended family. Hendon has a son and a daughter, and they're both married and married to wonderful people. And together we have 8 grandchildren, 7 boys, and just 6 months ago we got the first little girl.
Indeed.
She's precious.
She is that. And so just tell us a bit about your background. Where were you born?
I was born in Mobile, Alabama, September 17, 1946. That's Constitution Day, by the way.
Very good. You were destined for the federal bench,
guess.
I guess. And how did you just overall spend your childhood, summers, that type of thing?
My grandmother had 2 cottages at Gulf Shores that she would rent out, and she always saved one of them for the use of the family during the summer months. So I spent a lot of time over there during the summer. She then sold those and bought a house on Mobile Bay, and so we would go over there during the summer months. I always fondly remember I had some friends down there during the summer, and we would get on our bicycles and ride up to the Grand Hotel, and the guards up there would let us go in, and as long as we didn't bother anybody, they'd let us swim in the old swimming pool, which no longer exists. They replaced it, but that was my first and fondest memories of the Grand Hotel in Mobile Bay.
What did you want to be when you grow up? Did you think you'd be in the legal profession?
No, I wanted to be a doctor. And as we'll talk about later, those ideas evaporated when I found out I was so colorblind that looking through slides on a microscope, I could not differentiate between various components of what we were looking at. I mean, I'm really badly colorblind in that way.
Yeah.
So that just wasn't going to work.
Sure.
So.
But justice is blind, so you.
That's right. There you go.
Maybe that's why you do as well as you do. And so you stayed down in the Mobile area for college.
I did. Went to Spring Hill College, and was on the debate team at Spring Hill College, and that's where I met your mother.
You were debate partners.
We were debate partners. Yeah, we got married after we graduated from college. Sort of formalized the relationship of debate partners.
Yes, I can attest that the
You can
debates
attest
never
to
ended.
that. That's right.
And then you were in ROTC.
I was in ROTC, Army ROTC, and at that time my plans was to become a Army officer and make that a career. And so I went through that, and right after we got married, went on a honeymoon. I went to Fort Knox, Kentucky for training as an armor officer, and after that went to Fort Hood, Texas, where I was assigned to an armored cavalry that was part of the 2nd Armored Division, which is now inactive. But that was a great experience out there. We were there. We got there 2 days before Christmas of 1968. And I was at Fort Hood from 1969 until, the summer of 1970, maybe October of 1970, when I got orders to go to Vietnam. And first had to go to a school at Fort Bragg, and I did that for 6 weeks. And last part of that year, 1970, flew to Vietnam and spent a year in Vietnam as a military advisor in the southernmost province of Vietnam.
And how long were you in Vietnam?
1 year.
What was that like?
It was interesting being in a different culture. The Vietnamese have a very different approach to life. We would call it laid back. One of their favorite comments is "Nai Mai," which means tomorrow. And that's the way they sort of approach things, which was very aggravating to those of us who were trying to work with them and help them understand warfare. If we don't get it done today, we'll do it tomorrow. So that was an eye opener for me. But you're in wartime. You're in combat. Not all the time, but a good bit of the time. So you do your job and hope everything comes out all right.
And you had planned, you said, to have a
make
career in the
it a career.
military.
But as things happen in life, at the end of 1971, the Army began to downsize because it was clear that Vietnam was coming to an end. And I was one of 2,500 captains that got orders to go home, kicked out of the Army, if you will. That's a bad way to phrase it, but we were released from the service. Interestingly enough, during my time in Vietnam, one of my friends was a lawyer, but he wasn't practicing at that time, but he had a law degree. And we used to talk about that and what you're going to do after life in Vietnam. And so one of the thoughts that I had was the Army had a program where they would send you to law school, and if you agreed to practice law with them as a JAG officer. And so that was one of the thoughts that I had about what I was going to do after Vietnam. And then, of course, when I found out I wasn't going to continue in the military, I said, well, I still want to go to law school. So I applied to law schools and got in at the University of Alabama. I didn't do all that great on the LSAT, but I think I got in because I was a veteran coming home.
Sure.
I don't know that for a fact, but.
And at the time you found out that you were released from the military, were you happy or accepting of it, or did you think it was the worst?
It was a shock. There's no question about it. In retrospect, it's one of the best things that ever happened, but those are those experiences in life where you can look back on with fondness, but not during that period of time. It was very stressful because I had a child and a wife.
So it was serendipitous, but it didn't feel that way at the time.
That's right. That's exactly right.
So sometimes only with the benefit of hindsight can we see that something that we thought was terrible was actually
absolutely correct.
Was actually a good thing. And so you got into the University of Alabama for law school, mm-hmm. which I'm sure you had to move your family, wife and child to Tuscaloosa. And how old was Christine when you started law school?
Christine was born in 1969. I started law school in 1972. So she was, 3 years old?
Okay. And so when you started at law school, did you have a plan or an idea about what type of work you wanted to do?
Had no idea. I think anybody who goes to law school and says, I want to be this kind of lawyer, I want to practice this kind of law, is unless they have some experience with it, they really don't know. As time grew on, I became more and more enamored of the idea of doing trial work. I was fortunate enough to meet George Peaches Taylor, who was a professor at the law school then, and he accepted me as a research aide for him. So I worked with George, and that was a really good experience. Of course, George is a very good trial lawyer, and so that sort of whetted my appetite for that.
And how did you balance law school with having a spouse and a young child, and then eventually a child on the way?
Thank heavens, Michelle, my wife, was a big help in that regard. And but you get up in the morning. Children were young, so they weren't in school, thank heavens. And get up in the morning, get to the law school, go to your classes, find time during the day to study, and go home at night, spend a few hours playing with the kids, and then study late into the night. I would start studying 8:30 or 9 o'clock at night, and maybe go till midnight. So that's how you balance that.
And I was born when you were a 2L.
Yes.
Correct. So
yes,
that's a lot of work.
You were.
Going from 1 to 2 children is
yes,
like going from 1 to 10.
I remember those days when you were born. Several of my friends came to the waiting room while I was waiting for you to be born, and they brought pizza, and so we had a pizza party in the waiting room.
I remember hearing that.
Because in those days you couldn't go back into the birthing room with your wife.
So you ate pizza
We
while
ate
I was
pizza,
born.
that's right, which is probably why you still like pizza.
I do love pizza, that's for sure. And tell me about the Law and Psychology Review. You're the man when it comes to that, correct? You're where it all started.
I was one of the so-called founding editors of the Law and Psychology Review. There was a group of us who were a little bit rebellious, if you will, about the Alabama Law Review. You had to write on to the Alabama Law Review at that time, and it was, in a way, an unfair practice for students who didn't exactly have the background to be able to do that. And so, in conjunction with George Taylor, who helped us a lot, and the dean of the psychology department at the university, we developed this idea of having this Law and Psychology Review, which was really an untapped resource at the time. So the first edition of the Law Review was devoted to the mentally disabled, and all related to the White versus Stickney case at that time, the horrible treatment of those young people in Tuscaloosa, as a matter of fact.
And that case was here in the Middle District.
That case was here in the Middle District.
With Judge Johnson.
With Judge Johnson, yes. So it was really a very interesting time. It's very difficult for us. The only office, the law school gave us an office, if you will. It was a hallway that led from the first floor to the outside. It was about 12 feet wide. And we had desks on either side, and you could squeeze between the desk. And
did you envision that it would still be in existence today?
No, we had no idea that it would continue.
It would take off. I was a member of the Law and Psychology Review.
I know you were.
And do you have any mementos from that?
I have a plaque not a plaque, it's a certificate that says I'm a founding editor of the Law and Psychology Review.
And so how many members or how many people founded the Law and Psychology Review with you?
Maybe 8 of us, not many. We did all the spade work, did all the review of the articles. And of course, at that time, we didn't have computers, so it was all done with, just your
typewriters
and looking up the citations by hand. So it took a long time.
Yeah. And so while you were in law school and you decided you had a preference for doing trial work, did you have a particular area of the law that you liked? Did you have any sort of a plan or idea, or were you just going to go where you got a job?
I did not. I really was going to go wherever I got a job. I went through law school in 2.5 years. I didn't have any summer clerkships because I went to school during the summer. So I finished law school in December of 1974, even though I was in the class of 75. As it happened, Judge Eric Embry was elected to the Alabama Supreme Court, and his term began in January of 75. And so he was a good friend of George Taylor, and Eric was looking for a law clerk, and George recommended me to him. And so my first job out of law school was clerking for Justice Eric Embry on the Alabama Supreme Court.
And that took you to Birmingham.
That took me to Birmingham. We lived in Birmingham for a year. And when he had to be on the bench here in Montgomery, he would drive to Montgomery with Justice Red Jones and Justice Janie Shores, and I would drive them. That was a really interesting experience, sitting in the car with those three people and listening to their stories and listening to their conversation. Very educational. But that's all I can say about that.
If only you could recount
right.
those stories.
I'm not sure I can remember most of them, but
that'd be the history we would want to recount.
Yes,
I'm sure.
I know it would be. A lot of people would be interested in that.
And so then you clerked for the Alabama Supreme Court for a year.
For a year.
And did that hone your idea about the type of law you wanted to practice after that?
I really did want to do trial work. That's getting the opportunity to watch lawyers argue to the court and reading transcripts, and that really focused me on doing that type of work. And so no
interest in transactional work?
Absolutely not. Absolutely not.
And then how did you make a transition from Judge Embry to practice?
Well, again, Judge Embry, of course, was friends with a number of lawyers, and he was a good friend of Maury Smith here in Montgomery. And Maury's firm at that time was Smith, Bowman, Thagard, Crook, and Culpepper, and they were looking for an associate. And again, I was off the regular hiring cycle, but they wanted somebody to come in right away. They had I've forgotten what was going on where they needed a young lawyer, but nonetheless. So my first job after clerking was with that law firm, and which
is the precursor to Balch and Bingham.
Yeah,
here.
They merged with Balch and Bingham after I left. So I worked for them, did trial work.
Back when we tried more cases.
Back when we tried cases, yes, that's right. And that, of course, was interesting, carrying Maury Smith's briefcase, carrying Tommy Thagard's briefcase. Did a lot of work with them. That's what led to the second stage of my career, which was General Counsel of the Department of Education.
Well, before you move on to the Department of Education, Tell me about trying cases at Smith, Bowman, Thagard, Crook, and Culpepper. What were did you ever appear in federal court in front of Judge Johnson particularly?
Yes. I did. Judge Johnson appointed me to my first criminal case in federal court. It was a drug case. The police had arrested the defendant, chased him at night, and he threw a bag of drugs out of the car, and the police stopped and picked it up, and that was the basis of the charge against him. And of course, I argued, how could you know that was what he threw out of the car and so forth and so on to the jury, but the jury didn't buy that. So.
And then with Judge Johnson, did you appear in front of him enough to get the flavor of what it was like to practice in front of Judge Johnson when he was a district judge?
When he was a district judge, I did. And what it was like to appear in front of Judge Johnson was, you better be prepared and well prepared and know your case. And if you were prepared, there was no problem. If you weren't prepared, all hell would rain on you from him. He did not tolerate unpreparedness or fools gladly.
Which makes you a better lawyer.
Which makes you a much better lawyer, yes.
It can be scary, I guess, to
Yes.
be in front of someone like that, but at the same time, again, with the benefit of hindsight, it makes you better.
Absolutely.
And so I know you have some interesting trial stories, and I remember them from you just telling them at home when we were little, but one of my favorite stories is the one about Maury Smith and the box of pencils.
I was in the office one morning, and Maury walks by my door and says, "Charles, go grab a full box of pencils and come to court with me." And I'm going, "Okay. Do you want them sharpened?" "No." So I went to our little supply room, got a box of pencils.
Of unsharpened pencils.
Unsharpened pencils, put them in my briefcase, and off we went to the courthouse. As I recall, it was a criminal case. And so when we got there, Maury got the box of pencils and he put it right on the edge of the desk. And the trial proceeded. And one of the critical witnesses for the prosecution was on the stand. And the prosecutor asked him this question, and Maury jumps up and objects. And when he did, he knocked the box of pencils on the floor. And they, of course, scattered all over the place. And he, "Oh, I'm sorry. And we, I was down, he was down picking up pencils, and everybody was helping us pick up the pencils." And so when everything got back to normal and we had all the pencils back in the box, the prosecutor was ready to commence his examination, and he didn't ask that question. He went to the next question. He had his questions written out, so he just apparently skipped over those questions. And that's one of the
you saw trial strategy in action.
I wouldn't call it trial strategy. I'd call it something else if I were pressed. But yeah, Maury was a great trial lawyer, one of the best in this city, certainly, and probably in the whole state. He had a tremendous way with the juries.
And was there ever a time where you may have tried a case with an overcoat on?
You know about that.
I do.
Yeah, it was a domestic relations case, and I met with my client that morning, and she had to go move her car or something, so I told her, "Meet me at the courthouse." And I was walking out the door to go to the courthouse. The receptionist said, Mr. Coody, your pants are split wide open," and they were. I had ruptured the seam in my trousers. So thank heavens it was wintertime, and I got my overcoat, put it on, headed off to the courthouse, and it was in front of Johnny Davis, who was one of the domestic relations judges, and I told him, I said, "This is going to be a little odd, but I've got to try this case in front of you and wearing this overcoat," and I told him why, and he laughed, and that was interesting.
You tried your case with your coat on.
Tried a case with my coat on. That's exactly right. Did
you ever tell the jury why you had, or was there a jury?
No,
it was
not,
just a
not, not in
judge,
domestic relations cases, no.
And then the Mr. Transmission trial.
Yes. Michelle, my wife, was very pregnant. And
with Amy,
with
the
Amy,
third daughter.
And she went into labor the day before the case was set for trial. Amy wasn't born until 12:30, 1 o'clock in the morning. And so I was in the hospital with her until 2 or 3 o'clock. I finally was able to leave and go home, got a little bit of sleep. Trial was supposed to start at 8 o'clock the next day. So I got up that morning, got to the courthouse, bleary-eyed, and of course, as normal, my case was delayed because they hadn't finished the trial in front of us. we started that case. It was a fraud case against Mr. Transmission, and I was representing Mr. Transmission. We started that case in the afternoon, about 1 o'clock or so. And so when I stood up to address the jury with an opening statement, I told them that if I looked a little bleary-eyed, I apologize, but my third child was born last night. It was a little girl, and I was up late in the hospital. And there were several women on the jury, and they go, "Oh, how sweet," you know. So I was able to curry favor with that jury that way, and I won the case. My first jury trial, as a matter of fact.
So still balancing family and
That's right.
and work.
That's right.
That's what we do.
That's what we do. We all do that. Yes.
And so after you had some time in private practice trying cases, did the actual practice of law underscore your desire to be a litigator?
Oh, absolutely, absolutely. During the time with the private firm, they represented the Alabama Department of Education, Alabama State Board of Education. And this was a period of time when a lot of the desegregation cases were going on. It was a period of time when Title VII cases were being tried. You know, the state is always a target for litigation. And so part of working with the firm was working with the Department of Education. And over time, my practice really involved representing them a good bit of time. I would say probably 60% of what I was doing was representing them. And they had cases that had to be litigated, had to be settled. You know, part of being a litigator is learning how to settle cases. And so that became sort of my primary practice, which led to the State Superintendent of Education offering me a job as the general counsel for the department, which did not have at that time an in-house lawyer. And they doubled my salary. So it was quite an attractive offer, having now had 3 children. And so,
and which is unusual, going from private practice to government
right.
work and having it actually double
That's
your
right,
salary.
Because I wasn't a merit system employee, which would have depressed any salary that I had. I was one of the top people in the department who weren't covered by the merit system, so they could pay me that kind of money, and so it was so attractive I couldn't turn it down. And it was a challenge. It was a challenge to start something new. You know, build up a department within a state government. Fortunately, it wasn't as difficult a transition as it might have been if I were just new coming into that, because I had worked with pretty much all the people in the department for a long time. So it was a good transition. You know, get an office, hire a secretary, and go to town.
So you went from law school and creating the Law and Psychology Review to going to the Alabama Department of Education and creating a position there.
Yes.
So if you didn't find your path, you just blazed it.
Well, that's one way to put it. You know, life comes at you in different ways, and you have to be flexible, as they say.
True. And so you essentially put together the general counsel for the Department of
Yes.
Education from
Yes.
scratch.
Had to develop procedures and processes. Spent a lot of time working with the HR people within the department. So it was a good challenge, as I said.
And so
And some interesting litigation developed over those years.
Yes, like tell us about secular humanism. I remember as a child, I would hear you talk about secular humanism, and I said, "What is secular humanism, Daddy?" And you went, "Exactly."
Exactly, that's right.
So tell us about the secular humanism case.
The case arose because of a textbook that was a home economics textbook that had a chapter in it on values. And the chapter was related to, you know, be honest, be nice to people, don't steal, and so forth. Well, a group of individuals who have a different view about teaching values filed a lawsuit claiming that the teaching of values in the absence of reference to a deity, to God, was the civil religion of secular humanism. And so that was teaching religion in the public schools, and of course, under the First Amendment, you can't do that. That was the claim. They filed the case in federal court in Mobile, in the Southern District of Alabama, and it was assigned to Judge Brevard Hand, who was a wonderful, wonderful Southern gentleman. He'd been on the bench for quite a while, but he had his own personal views about religion, and so it made the case for us very difficult. Judge Hand appointed his own expert, which he can do under the federal rules. This man from Florida who came in and explained in great detail how teaching values without reference to a deity was secular humanism, the religion of secular humanism. But we tried the case. We had our own experts, and the case was tried. I think we tried it for about 3 or 4 days, but it was pretty obvious from Judge Hand's comments during the case, which was non-jury, where the trial was going. So even though we were trying the case, we were also preparing for the appeal. Well, at the end of the case, before he entered any final opinion, he preliminarily enjoined us from using that textbook. As we proved at trial, because we had a suspicion we were going to have to appeal, the textbook, according to the cycles, all the school systems follow kind of a set cycle when they teach particular things. So that section in the textbook had already been taught. It was not being taught anywhere in the state. So we took an immediate appeal from the preliminary injunction, and I upset Judge Hand a great deal with the brief that I filed pointing that fact out, but I also referred to his enjoining the use of the textbook as a draconian remedy. He didn't like that term. The 11th Circuit, however, apparently did, because they very quickly overruled his preliminary injunction. So we won that case. But it was a difficult case, not from the standpoint of trying it. It was a newsworthy case, and the media was all over it. And one of the things that it taught me is how to deal with a high-profile case where you have constant battles with the news people, all the press that's involved in it. Makes it very difficult because it's not part of the case, it's external to the case. Very, very hard.
You're somewhat shielded from a little bit in federal court. But
you are a little bit, but not when you represent a public entity. That's, you can't just say I don't want to talk about it, but you have to say that.
And you also had the teacher testing case.
The teacher testing case. The State Board of Education decided that they wanted to require new teachers to take a test, either a general test if they were elementary school teachers, if they were subject matter teachers, teaching history, teaching science, teaching math, that they should pass a test to make sure that they were knowledgeable enough to teach in the schools. The department spent a lot of time and money developing this test. They used a professional test developer, went through a lot of precursors to the test development process. And so the first test was given, and it had tremendous impact on the African Americans who were trying to get into teacher education.
A disparate impact.
The disparate impact, yes. The passage rate for non-whites was like 4 times less than, the failure rate was 4 times less than the passage rate for white students. Really, really bad. And of course, there was a lawsuit. And that was, again, one of the more difficult cases. I actually brought in David Boyd from Balch Bingham at that time. Dave had been a young lawyer with me at Smith Bowman. And so he and I worked on that case, spent a lot of time with experts, learned a lot of interesting information about testing and the development of tests. Judge Thompson was assigned to the case, and let us have a good bit of time to do the discovery in the case. But I tried to settle the case, but was unsuccessful. We tried the case, and we lost. And so we were sent back to the drawing board to develop a test that did not have disparate impact. 10 or so years later, the case finally settled along the lines that I had originally suggested.
Why not do a decade of work?
Well, why not?
When you can.
That's right. Why not spend all that money? But again, those were difficult times. I think that we. I think that case, more than any other case, showed the difficulty, at least showed me the difficulty of dealing with the bureaucratic approach to solving problems. There was always a question about whether or not the test was necessary to begin with. If the teacher education schools at the universities were doing their job, why would there be need for a test? And so it really was more of a political response to perceived problems in education. Education always has the political overlay that is very difficult to deal with.
And so you were involved in litigation, and then there's obviously that was complex litigation.
Yes.
And lengthy. Did you have an eye toward wanting to be a judge, particularly in the Middle District, where you were practicing?
You know, I think every lawyer thinks about that, and I certainly did. Having the experience over here in the old courthouse, practicing in front of Judge Thompson, practicing in front of the other judges, the other judge, Judge Varner, made me really sort of desire to take that approach. There were 2 magistrate judge positions. Judge Gwaltney had been here for a long time, and I think Judge Dabina was the first to occupy the 2nd position. I think it was a newly created magistrate judge position. And so when it opened up, I applied, a number of other people applied. Judge Dabina was selected as a magistrate judge. And he acted as the magistrate judge for several years until he was appointed to the district court bench. So the position opened up again. I applied again. John Carroll, who was selected.
And he had been at the Southern Poverty Law Center.
He'd been at the Southern Poverty Law School. He was the dean of the law school in Georgia. So he's, comparatively, he was much better qualified. I hate to say that. He'll like that. Then Judge Gwaltney retired. And so John came on board in November of '86, December of '86. Judge Gwaltney retired at the next year, and his position opened up, and I applied the third time, and third time was the charm.
Never give up.
Never give up. That's exactly right.
And so how did you find out you had been selected?
Judge Hobbs, the chief judge at that time, called me on the phone, and I answered the phone with some trepidation. He said, "Charles, welcome to the court family." And you've heard that phrase before, I know. And this court really is a family. Not all courts are families, but this court really is a family of good people who are marvelous to work with.
I don't know if I've ever told you this, but I remember when you got the call. You were sitting at the kitchen table and you answered the phone, and I heard you answer the phone, and then I saw you went, yes. And so I asked Mom, what's happening? And she said, your father's going to be a judge. So I remember the call myself. So, and you're right, it is very much a collegial group. I think the Middle District is special in that regard. And at the time that you got the phone call from Judge Hobbs, did you think, this is what I'm going to do for the rest of my life? Did you think about it?
I really didn't think about that. This is what I wanted to do, and looking back on the almost 35 years, I've just been perfectly happy. I love the job.
And so your early years on the bench, then it was you and John Carroll.
John Carroll.
And I know that just from being around you and Judge Carroll, and then now here, that the position of magistrate judge has evolved significantly.
We evolved it significantly. When we started out, we were overrun with prisoner cases. At that time, the number of prisoner cases filed each year in this district varied between 900 and there was one year where 1,100 of them were filed. And so there was a huge backlog of cases. It just
and most pro se.
All of them pro se, yeah, with rare exceptions, all of them pro se. And they're very difficult to deal with because of that. So one of the first few challenges that we had was working through all those cases. But we did. We got the caseload down to a manageable level. And then began to talk about we're doing very little to help the court in other areas that we are statutorily authorized to do. The only criminal work that we did when I began was the misdemeanor cases that were in the court, primarily coming from Maxwell Air Force Base and Fort Rucker. And they were misdemeanor cases. They were violation notices. People would get speeding tickets, and those had to come to federal court. But we wanted to expand our responsibilities, so we began to talk to the district judges about doing that. One of the first areas that we did was doing the preliminary work in felony criminal cases, and magistrate judges are authorized to do that, hold initial appearances, hold suppression hearings, and so we were gradually assigned those kinds of duties, I guess, after we proved that we could handle those matters. Over time, we also were placed on the wheel. The wheel is the process by which cases are assigned to judges. We already were being assigned as magistrate judges on all the civil cases, and we began to handle all the civil discovery. So the last thing that was added were consent cases. Under the statutes, parties can consent to a magistrate judge having full authority to try and resolve a case. And so we developed a process by which the parties were notified that they could consent to one of us handling those cases. And that over time develop. And I think there's a pretty good consent docket now for the magistrate judges. So it was just a gradual process of increasing and expanding the authority and responsibility of the magistrate judges.
And in fact, this district, I think, was the first federal district in the United States to make full
utilization
use of the magistrate judges.
That's right.
Under the authority of the statute.
That's right.
One of the first.
Yeah. 28 U.S.C. Section 636, the Magistrate Judges Committee of the Judicial Conference always encouraged full utilization of magistrate judges, and we followed that and were applauded for that.
And then reports and recommendations, even in non-consent cases,
right.
That is a significant
yes.
benefit to the court.
One of the benefits that happened, or one of the good things that happened, it was 1996, I believe, Congress passed the Prison Litigation Reform Act. Up until that time, prisoners could file pro se and would get a free ride. That didn't cost them anything to file a lawsuit. Under that particular statute, prisoners were required to pay a percentage portion of any money that they had to file their lawsuits. That cut our prisoner filings literally in half. We went from like 950 to 425 in 1 year, just boom. And so that made it possible for the magistrate judges to do more work.
Sure. And then it evolved from us having 2 magistrate judges
to 3, then 4.
And we now have 4.
Now have 4. And also, this is, I think, one of the only, if not the only, district in the country where the number of magistrate judges exceed the number of authorized district judges. I think we're authorized, 3 district judges right now, and we're authorized 4 magistrate judges. And we continue to get approval for that every year.
We do.
Every 5 years. That's the cycle of approvals.
And it's largely due to the full utilization
that's right.
of the judges as well. And it is, and of course we have had consistent vacancies with the district judges.
Yes.
So the full utilization and number of magistrate judges has enabled the court to function and function well, I think. And so then it was you and Judge Carroll, and then we've obviously had Judge Susan Walker.
Judge Zeta McPherson, Judge Dolores Boyd,
and then Terry Moore.
Judge Terry Moore, who was a magistrate judge, appointed as a district judge in the Southern District,
right.
where he is now.
Judge Wallace Capel.
Wallace Capel. And who else? Who are we missing?
I probably shouldn't have started naming names because
I'm
afraid I have forgotten somebody. But and then of course now we have Stephen Doyle.
Stephen Doyle, who came from the U.S. Attorney's Office, and Kelly Pate.
And Jerusha Adams.
And Jerusha Adams. Jerusha came from the U.S. Attorney's Office. Kelly came from private practice.
And well, Jerusha Adams, Judge Adams, had been at the U.S. Attorney's Office and then went to private practice briefly before coming on the bench.
One of the interesting things about our particular district is the diversity in the magistrate judges that we've had, both women and people of color. That's always not a requirement, but a desire on the part of the powers that be, the Judicial Conference. Wants to increase diversity, and we certainly have met that, which again I think is another reason why we've been favorably blessed with having 4 magistrate judges.
We have. And you were, as a part of the magistrate judge duties and work that you perform on behalf of the court, we have the mediation program here in the Middle District, whereby the magistrate judges will mediate a case for the parties free of charge. Free of charge. Which is a huge benefit. I know as a lawyer practicing here in the Middle District, the cost benefit of having a magistrate judge mediate a case was significant, as well as enabling the parties to come to the courthouse and talk to a judge.
Yes.
Enabled the feeling of having my day in court, even though we were in a mediation.
It did.
And so how did you view mediations? You have certainly a reputation of being a very good mediator.
I enjoyed mediation a lot. It gave you an opportunity, one, to resolve a case, as you pointed out, without a great deal of expense. But it also gave me, as a judge, an opportunity to talk to not only the lawyers in a non-judicial setting where I don't have the bench interposed between me and the lawyers. It gave me an opportunity to talk to the people, the litigants who were involved in the case, as persons, and that was always an enjoyable aspect of it. There's no pat process to mediation. You have to ensure that the people understand their case, and typically the lawyers have done a good job of explaining both the benefits and the burdens of going to trial, which is always, of course, a danger. You never really know what a jury's going to do. And that's part of the spiel that you have as a mediator. But I think most people are rational. Most people understand that risk, and they understand that compromise is better than the risk that they may face. It's interesting. You never know how mediations are going to develop. There was a lady from Dothan who had a small business, and she had contracted with the telephone company to put an ad in the Yellow Pages. And for whatever reason, the Yellow Pages didn't have her ad, and she was very upset about that, and so she sued. And the problem with her lawsuit was damages in that arena are very speculative. So I was talking with her, and she said, well, I've got to have $30,000. And it occurred to me why that specific figure, what was the driving force behind that. And this is what she said. She was driving, I said, I was driving up from Dothan, and I passed the Cadillac place, and there's a red Cadillac on the lot, and it's got $30,000 on the windshield, and I want that car. So I got with the defendants, and it just so happened that one of the lawyers on the defense side also represented the Cadillac dealership. And so he was able to work out something with the dealership to get her that car for a lot less than $30,000, I'm sure. So you just never know what motivates people to want particular sums of money. And a lot of times litigants are able to work these things out themselves. There was a horrible wreck involving two 18-wheelers that ran into each other. And so I got the companies together that in the mediation, and both sides had their risk people involved. And I had begun talking with them for just maybe 5 or 10 minutes, and one of the risk adjusters said, Judge, can he and I talk? I said, sure, y'all go ahead. And they went in one of the jury rooms that wasn't being used, and 15 minutes later, they came out and said, okay, we got a deal. So that was one of the easiest mediations I ever had. Let the parties do it.
Yeah. Sometimes you just have to get people together.
You do. Sometimes you have to get people together. You have to have them talk to each other.
Which people don't do as much
no.
anymore.
That's part of the problem with litigation is the lawyers separate people instead of bring them together, and that's what mediation does. It brings people together.
Well, you had some high-profile people come through your court. Younger people might not know who F. Lee Bailey is, but he was a very well-known lawyer. Well-known
criminal lawyer. F. Lee became Flea Bailey, and that's well taken because I had never seen him in person before until he appeared in my courtroom, and he was representing a drug dealer from Miami. And when he walked into the courtroom, I understood why had the nickname Flea is because he's very short. I'm not sure he even reaches 5 feet. And sitting on the bench, I had to look over the bench so I could see him. But it was interesting. There was a detention hearing in regards to his client, and apparently the word had gotten around the courthouse that F. Lee Bailey was here, so it was all the law clerks, I think, in the building were in the back of the courtroom watching him. And at one point during the argument, when he was arguing about his client ought to be released on bond, he said, "Judge, it's just 4 kilos of cocaine." And I couldn't help myself. I had to respond. I said, "Mr. Bailey, 4 kilos of cocaine in Miami may not be a lot, but in Montgomery, it's awfully a lot. It's an awful lot of cocaine."
That is indeed.
Yes, indeed.
And then I know. Tell me the story about Hrap Brown was a defendant here.
Hrap Brown had a long history of criminal activity. As he was a militant and well known. He was charged with something, I don't recall what, in Atlanta, but he escaped Atlanta and was found in the Middle District here, and he was arrested by our marshals, who always have a remarkable capacity for finding people. So when he came in for the initial appearance regarding the charges in Atlanta, I asked him to stand, and I said, "Mr. Brown," I told him why he was here, and he interrupted me and said, "Judge, my name is," and he had become a Muslim, and he took a Muslim name. The prosecutors, the marshals refused to call him by that name for whatever reason. But once he told me what that name was, I called him by that name during the rest of the proceeding. And you could see that small treatment of him made a lot of difference to him as a person. And I use that as an example to say that we deal with some of the worst people who have committed crimes, but they still are human beings. And one of the things that this court must uphold is the notion of equal justice under the law. We must treat people as human beings. We must respect their dignity as a human being. Regardless of what they have done, they still should be treated fairly and equally. And so that little thing that I did, I always remember that it brought home to me the necessity to do that. So I felt good about that.
Well, in order for there to be respect for the court, we have to show respect to the people who appear here.
That's exactly right.
And that is a good example of that, and a good reminder that people come to court with an expectation just
Yes.
as much as we have expectations of people who come here.
That's right.
And that sometimes just treating somebody with respect and makes a huge difference. And so you also, after you came on the bench as a magistrate judge, you did some work on desegregation cases.
Oh, yeah.
And did your experience with the Alabama Department of Education help you in that regard?
It did indeed. Levy-Macon was the primary desegregation case in the state regarding the elementary and high schools. At some point, the desegregation cases were divided between the districts so that every district had cases just involving the schools in their district. Most of those cases concluded in the 70s. When I say concluded, so-called terminal orders were issued that require the school boards to desegregate, place certain responsibilities on the school boards. For example, they were required to seek court approval if they built a school, if they changed districts, changed school lines within their boundaries. Judge Thompson and Judge Albritton were looking at those cases and realized that many of those cases had languished for years. I mean, we're talking late 1990s. Nothing had been done for 20 years in some of these cases, and yet they were still active, they were still open, they'd never been closed. So they decided to begin the process of resolving those cases. To resolve those cases, it requires that a school board seek unitary status. That is, unitary is the term of art, meaning that they have been fully desegregated. That process takes about 3 years because it requires that they file reports, it requires that they demonstrate as a factual matter that they are no longer discriminating against people of color. The first one of those cases that I began to work on was the Montgomery County school system case, which had been one of the more difficult desegregation cases in the state. As a consequence of that, I spent 2 weeks meeting with school board members, talking to them about the advisability of settling these cases. It was a twofold approach. One is you need to accept responsibility for your school system and not have to run to a federal judge every time you want to do something and get approval for what you want to do and what you think is the best approach. And the second approach was, under the law, while that terminal decree existed, if you were sued, you had the responsibility to prove that you didn't discriminate, as opposed to the typical case in which the plaintiff would have to prove that they had discriminated. So the burden of proof was on them as long as those orders existed. And that's a very powerful reason to want to settle those cases. So we began the process of working with not only the school boards but also the plaintiffs' lawyers. And I have to recognize, especially the Fred Gray law firm, Fred and his sons, undertook that process gladly and willingly. And so it was a great example of something that I think is less extant today in the practice of law, and that is lawyers on both sides recognizing a problem and seeking a solution, as opposed to just being at loggerheads all the time. But over time, we worked through all of the cases. All of the cases were eventually resolved by a hearing before either Judge Thompson or before Judge Albritton, and orders were entered declaring the systems unitary. There's only one case left now, and I think Judge Watkins has that case. But it was a great experience, but I was helped by my experience in the Department of Education because I understood school law, I understood what boards of education did, and I understood the impact on them.
What have been your least favorite aspects of the job? And along those same lines, you know, threats against federal judges have increased hundreds of percentage points
yes,
over the last few years.
You know, that in a way that's not really an aspect of the job. That's just I think that's a situation that exists because of the times in which we live.
You know, of course, you were on the bench when Judge Vance was killed.
Yes, that was a very difficult time. I know you probably remember his daughter lived and husband
Judge
lived.
Godbold's.
Judge Godbold, that's right.
Daughter.
Judge Godbold's daughter lived across the street from us, and Judge Godbold would often visit with them, especially on the weekends. And during that period of time, he had security from the marshals. And your mother one Saturday, I think it was, made some cookies, and we were going to take cookies and drinks across the street to the marshals. And y'all walked out the front door, and the marshals alerted, and I had to walk out and say, "It's okay." And I introduced myself. They didn't know who I was. But those were difficult times. I had worked with Judge Vance when he was still practicing law on an antitrust case, and he was quite an individual and very, very much loved. But aside from that, and that's just part of our life, again, you can't worry about that. You just have to be cognizant and do the things that you need to do to take care of yourself and your family. But I think the thing that is the least fun in the job is the repetition of the scripts that you have to go through. For example, when you're taking a guilty plea, there really is a set script that you ought to follow, because you have to make sure that the requirements of Rule 11 are met. And so when you have 3 or 4 guilty pleas set during a day, you're constantly going over the same material. And the reason that's difficult is not because you're having to do it repetitiously, but because you have to make certain that in going through that repetition that you're cognizant of the individual in front of you, to make certain that that person understands what they're doing, they're pleading guilty, understands that the consequences of that. And so that's the aspect of judging that I don't like as much.
Sure. Well, and we say we have a script, and it may seem to someone as though that means we're not approaching something on an individual basis.
Right.
But when we say a script, it's because we want to ensure that we have.
Sure. Just like we have an outline of what we're talking about,
right.
We want to
you don't want to miss anything.
We want to make sure we don't miss anything. We want to make sure that the requirements of the rule are followed.
And the circuit has told us you have to say X,
yes.
Y, and Z, or we will send it
Absolutely.
back to you. So you
yes.
don't want to.
You don't want that to happen.
You don't want to increase the workload of the circuit because you missed something.
I would hate to increase the workload of the circuit.
And at the same time, you have, like you said, you're taking guilty pleas. You do 3 in a day, and it feels like you're doing the same thing, but you do have to remember.
Yeah.
For each individual, they've
That's
never
right.
heard it before.
That's right.
Or this is their moment.
Absolutely. And again, you have to be cognizant of that individual because this is a serious matter for them individually.
Sure. Well, and you don't just serve as a magistrate judge. You have administrative work that you have to do. You were the chief magistrate judge for 7 years.
And that's that primarily is serving as a liaison between the district judges and the other magistrate judges, and that's just a good experience. But we're in that sense.
You're not the boss of the other
not
judges
the boss
when you're
of the
the
other
chief.
judges, and so in that sense, you have to practice collegiality, as opposed to being a dictatorial judge. Which you shouldn't do with your co-equals.
Exactly.
But I've been fortunate to have had some administrative responsibilities, been appointed to a judicial conference committee.
And tell everyone what's the judicial conference.
The Judicial Conference of the United States is the governing body of the federal courts. It consists of the Chief Justice, the chief judges of each of the circuits, and then one district judge from each of the circuits. In order to do its work, they have established a number of committees that make recommendations to the Judicial Conference for actions that they should take on various matters that come before the Judicial Conference. The committee that I was appointed to and served on for 6 years was the Committee on Case Administration and Case Management, Court Administration and Case Management, CACM. And that was very interesting. That committee has the broadest responsibility of any of the committees the other committees of the Judicial Conference are very focused. There's a rules committee for both the federal and the criminal rules, the civil rules and the criminal rules. There's a committee on technology. There's a committee on buildings, space management, and a number of other committees. But CACM has the broadest responsibility, and as part of that work, they often had to work with other committees. And so that was very interesting. One of the responsibilities of that committee was the the electronic case management system that the courts use. And I guess we'll get into my work on that if you want to talk about that.
Yeah, well, how long did you serve on the CACM committee?
6 years.
And you were the only magistrate judge from in the country?
There's only one magistrate judge on the committee at a time.
And through that work on the committee, you actually met as a committee frequently, or do you
Twice a year.
To Washington,
Twice a
D.C.?
year. And then, there are certain times we'd have phone conferences during the other part of the time.
This was before Zoom, I guess, so you do telephone.
Absolutely before Zoom. The briefing book for each of our committee meetings was probably 500 pages long of various matters that came before the committee. So it was a good bit of work to digest all that,
That's the type of behind-the-scenes work people maybe don't recognize, that
that's right.
As judges we have a responsibility for the administration of the courts.
But even before my time on CACM, I worked on the next gen of the case management electronic case file system.
Yeah, so the advent of electronic filing and CMECF was probably one of the most significant developments in the federal court system in a long time.
No question. When I first came on the bench, we had paper files for each case. When I would come to work in the morning, I'd have 30 or 40 files stacked on my desk with motions on top of the file that had to be ruled on.
That had been paper filed.
That had been paper filed.
Everything
was paper file. That was the actual piece of paper that a lawyer or a litigant filed. And one of the terrible things about that whole system was different judges would have the same case. So the district judge would have a case, I'd have responsibility for that case, and of course the clerk's office had the case file. We used to spend 2 or 3 hours a day hunting files. Where was the file? Whose office was it in? We actually developed a charge-out system so we could figure out who had the file, and it worked sometimes.
Which is very inefficient.
Very inefficient. So the development of the electronic case file system, where you could get on your computer and look at documents that had been filed, was really a marvelous change for the system, and marvelous, made our efficiency go up. And
well,
so
even just as the practicing lawyers, they could file something electronically from their desktop as opposed to printing it, physically signing it, giving it to a runner, and having the runner drive it over to the courthouse to file it in the clerk's office.
Yeah, I didn't think about it in that way as a judge, but you're right. That certainly made the practice of law much more efficient, and much less consuming money. So.
Right.
2009, I was asked to come to Washington to participate in a meeting about the development of the next generation of CMECF, Case Management Electronic Case File System.
Was that because of your work on the CACM committee, or because of your interest in
No, because of my interest in electronics. So a group of us met, judges, clerks, law clerks. We met at the federal courthouse in D.C., and we were tasked with the idea of to express what you liked about the current system the legacy CMECF, and what did you dislike about it? And that was characterized as describe the operational pain that you experienced from the use of that system. To make a long story short, the original CMECF system was designed primarily to assist the clerk's office. It wasn't designed to assist chambers. There were a few reports that chambers could run, but they were very limited, and they weren't very good. So that was the task that everybody identified: develop a system that allows judges to manage their cases. You know, one of the unfortunate things that has happened to the federal judiciary over the years is we have become case managers. You know, our job is to resolve cases, but instead of often deciding cases, we simply manage cases to a conclusion that comes about by mediation, that comes about by the lawyers settling their own cases. So because we're trying less cases, we primarily manage cases. You know that we also primarily decide cases, if we decide cases, on the basis of the paper summary judgment process. So managing these cases is a very important part of our work, and the Next Gen project was designed to move forward that aspect of it. So after that initial meeting, I was appointed to a committee, part of the committee of the Next Gen process, and I spent literally years working on the calendar aspect. As you know, the calendar is an extremely important part of the case management process. We have to have our calendar set so that we know what we're doing, when we're doing it, and it's also important for the litigants, the lawyers. And the idea was to develop an electronic calendar that would facilitate the work that we do. Unfortunately, over time, it became obvious that that part of the CMECF system simply wasn't going to function. There wasn't an electronic, there wasn't software that existed or could be developed that really would perform the function that we wanted. We were told at the beginning of that system, think outside the box, think the best thing you would ever have, you know, everything that you ever want. And so the committee that I was on, we did that. We tried to develop a calendar system that would track leave, that would tell you what courtrooms were being used, would tell you what courtroom deputies were available to be used, and so forth and so on. And in a large court, that's important because oftentimes courtrooms are shared and courtrooms aren't available. It was too much. And so unfortunately, what I think maybe last year or a couple of years ago, we were all notified that the calendar aspect of CMECF was not going to continue to be developed. So that was an unfortunate aspect of it. But there are many other things that came about that were good. I think you're probably experiencing some of those things now. Useful reports. And so I think the work that we did was very beneficial to the courts.
You know, some of what I did as a lawyer, I primarily use CMECF for filing my documents or for going and looking at and verifying things that other parties had filed. But I don't know that there's a very good communication to the bar from the court about what CMECF looks like on our end and how the court uses it, which I think if that is communicated better would help attorneys help us, because I think if they file things in a certain way and have a document filed under a certain heading, it matters to us how it shows up on our end.
Right.
Talk to us about what it is that shows up on the judge's side of CMECF that helps us manage our dockets. For example, if a document is filed under the heading motion, what does that do on the trajectory of the system to help the judges move that motion forward?
Well, we of course see the entire docket sheet. We can see even the things that are filed under seal that typically the lawyers and certainly the members of the public can't see. But, for example, a motion, when that appears on the docket sheet, there's a little gavel that appears in the line with the motion that indicates to you that this is a motion that needs to be ruled on. One of the things that it generates, though, it generates a report every night of motions that had been filed or documents that had been filed in every case. So typically what I do in the morning is I pull up that email. The system sends an email at midnight that lists all of the things that have been filed and all the cases assigned to you. And I go through that list
On that
previous day. So that's the first thing we look at. It simply makes our lives much more efficient. It enables us to sit at the computer or look on your cell phone or look on your iPad and see the documents that have been filed and review those documents to see if there's any action that you need to take.
And so if a lawyer has a motion, but they don't file it under the heading motion, it won't get that little gavel icon that will alert the court that there's some court action that's necessary on that particular document.
You're correct, but typically the clerk's office will pick that up. They will catch that and they will characterize it properly. So,
which is, again, a part of the importance of the court family. And that
Exactly.
is we've got stopgaps to help us ensure that even if something is not filed as a motion, the clerk's office will catch it and docket it as a motion.
Yes.
So it gets the gavel icon
Gets the gavel
and our
icon.
attention.
That's right.
And that's part of the way in which we help ensure that things don't languish.
Right.
And part of that is the reporting system.
That's exactly right. You can generate reports of your pending motions. I do that every Monday to look at what motions are pending on the cases before me. I don't run it every day because I am able to review everything every day, but that's a good reminder about what's pending. And it enables us to create a workflow within your chambers so that when a motion is filed, it's assigned to a law clerk or it's something that you can handle. We can very quickly dispose of some motions by simply making a docket entry. We tell the clerk's office to make a docket entry. So it simply makes everything more efficient, and it makes us able to focus on substance rather than process. And that's important.
And just practically speaking, CMECF is one of the things that enabled the court to continue to operate so smoothly during COVID.
During COVID, yes.
Because people could remotely
handle all the work,
access files.
Yep. And I still do that. I mean, I'm semi-retired, if you will, and I'm responsible for 40% of the prisoner cases in the court. And in conjunction with working with the pro se law clerks, we have 3 of those. I handle that case, and I do all that remotely. So I can read all those filings, and I do read all those filings that come in from the prisoners.
And the technology of CMECF, with input from judges like you,
Yes.
and practitioners and law clerks, continues to evolve.
Yes, hopefully it will.
And so you've also, in addition to your interest in technology and the interaction between technology and the court, you've seen a lot of evolution just over the years of the practice of law and judging. Tell me about, after having been on the bench for a while, you had a history of being a debater.
Mm-hmm.
you helped Mom,
I was.
who was a debate coach
Yes.
here in Montgomery.
She was a debate coach at St. James.
At Lamp, beginning at
And
Lamp.
beginning at Lamp and then at St. James, yes.
And so you had a lot of work that you did on your own time with debaters.
Right. I enjoyed that very much, working with them. In fact, one of our top debate students is now a federal judge in Birmingham. So
Judge Manasco.
Judge Manasco.
Yes.
So I'm very proud of her, just as I am of you. But working with those young people and dealing with the issues that they dealt with, just keeps you fresh and young.
And a lot of those young debaters went on to the legal profession.
Went on to the legal profession, went into banking, went into international relations. So that's a good starting point for them. And in fact, my oldest grandson is now on the debate team.
Yes. At Newman.
At Newman.
In New Orleans.
Newman in New Orleans.
So your career has been quite an intersection between education and the law.
Yes.
And so
most definitely.
Looking back on that, what is your overall view of the importance of the intersection between the law and education?
Well, you can't have law without education, obviously. But when you talk about the intersection between the two, I think you have to be realistic about where the law is now. Again, going back to what I said earlier, when I first started practicing law, lawyers were much more collegial than they are now, unfortunately. And so I think the focus of the practice of law then was, clients have a problem. How can we solve that problem? And I used the we to mean the lawyers on both sides. During that early period of time, much of the complex litigation was about institutional change. The White versus Stickney case. We're still seeing some of that now with the prison cases. But over time, I think the focus has switched from using law as a device to effect institutional change. Now law is being used to effect societal change. All of the issues, the very contentious issues that exist in our society seem to wind up in the courts. And I think that part of that is an evolution of the failure of education to instruct people about the history of this country, the reason that we have should have a set of shared values about what this country means. There's a lot of talk about the decline of democracy in this country, and that's very worrisome. So education, in one sense, can be termed propaganda, but it needs to be something that looks toward the future and what people need to understand in order to be able to function effectively in our society.
And so how have you seen then the practice of law change and evolve over the years?
Well, again, it's become less collegial. It's become much more contentious.
Do you attribute that in any way to technology because people just don't talk face-to-face as much as they used to?
I think that's an aspect of it. At one point, one of the requirements that the federal rules require is before filing a motion, a discovery motion, that the lawyers talk. The rule doesn't say that. The rule, forgotten what the term the rule uses, but I actually developed a order one time that required the lawyers to talk to each other at least by telephone, because lawyers don't talk. We email, and now everybody text. And that has done away with, the personal, person-to-person that I think is so important for lawyers. But again, that relates to the decline in collegiality.
And as you look back on how the court has changed, particularly here in the Middle District, do you note any changes? Or obviously we have more magistrate judges than when you started.
Right.
You were here. The courthouse.
The courthouse
was built.
This courthouse was built, and that was primarily the work of Judge Albritton and Judge Thompson and the other district judges who had to fight to have a courthouse, not a building with courtrooms in it. And there's a difference. If you compare the Hugo Black Courthouse in Birmingham, it's a building with courtrooms in it. This is a courthouse, a place designed specifically for courts. And there are three levels in this building, if you will. There's the public area, there's the secure area, and then there's the prisoner area. In the old courthouse, I always knew when it was time to go to the courtroom, because you could hear the clank of the ankle bracelets that prisoners were wearing as they walked down the public hallway to get to the courtroom. Of course, that doesn't happen here. We have prisoner tunnels and the elevators that go right up into the holding cells outside the courtroom. So it's a big difference. That's a huge difference that has changed with this courthouse. In other ways, this court, I think, hasn't changed. That's good, and that is the collegiality that exists among the judges here, which is not true in every court. The bigger the court, the more difficult it is to communicate. Sure. And we're very fortunate to be as small as we are. And of course, all the judges know each other, and magistrate judges have practiced before the district judges, so it always has been a very collegial court, and that's, we're friends. We're part of the family.
When you look back on your career, what stands out to you as some of the most important aspects of your job and quality of life as a magistrate judge?
One of the responsibilities that magistrate judges have is to assist the district judges in carrying out their duties. And so we do that with the responsibilities we have, which often interrupt your whole day. For example, we hold initial appearances when a person is arrested. That tells them what the charges are against them, make sure they understand those charges. That can happen any time of the day. There's no set time when people get arrested. And so you may have your day planned out and it gets interrupted by those kinds of things. So our daily experience as magistrate judges hopefully is different from your experience as a district judge, because you don't have those interruptions. And so that's one of the things that we serve the court to free you up from being able to focus on your responsibilities. That's just one aspect of it.
When you started in 1987, did you think you'd be talking about your 35-year career?
I did not. No, I didn't know what you look back on that. When I first began, we had IBM Selectric typewriters with the old ball that went around. It's amazing how things have developed over time.
And some things change and some things stay the same.
Some things stay the same.
And so what are you doing now? You mentioned you do 40% of the
We live in Birmingham. Hendon and I moved to Birmingham about 3 years ago. And we wanted to move up there to be near our young grandchildren. You've got two boys that we dearly love. And my oldest grandchild is in New Orleans. But Hendon's children have grandchildren now. We've got, 4 little boys and 1 little girl who's 6 months old. She was born 6 months ago, and she's really a delight. And so, we're working with grandchildren, and I work on the cases when I need to. Do it all remotely, and that's been a real joy.
Which would not have been possible back in the day.
No, it would not have been.
So that's another benefit of
Right.
technology, because otherwise you probably wouldn't be able to continue.
Wouldn't be able to do it. I would not have been able to continue.
And you're doing that on recall status.
Yes, recall. That's the official title for where I am. I retired and am now recalled. I know that sounds like I'm defective in some way, but
it means the opposite in the law. Recall is good.
Recall means I have been recalled to duty.
That's right.
To assist the court.
That's right. And so essentially you're working for free.
That's right. Yeah, I am, yes.
Thank you for your service.
You're welcome. I'd get paid whether I did it or not.
That's right. That's right. Well, how do you feel about having a child on the federal bench?
I am just as proud of you as I can possibly be. I
sort of pushed you out maybe a little bit.
Well, there was a question when it was clear you were going to be appointed as to whether I could continue. I think we're the only father-child
I think that's probably right.
in the country. But as it turns out, because I'm a magistrate judge, the anti-nepotism statute doesn't affect us. So we had to get an opinion from the General Counsel of the Administrative Office to ensure that we did our due diligence. It was very interesting. So it has been enjoyable to watch you mature in the job and develop. I ask you a question. Do you feel like you still know what you're doing?
I learn something new every day.
Yes.
And I think it's part of why we call it the practice of law instead of the perfection of law, because it is just...
No question. And even after 35 years, I learn something new every day. So that never changes, and that's one of the wonderful aspects of the job.
That's true. Well, I know when I came on board, it felt like a homecoming because I grew up essentially at the federal court because of you. And I tell people that growing up with someone who loved his job, which you clearly did, has an effect on a child. I think even if you didn't say it, we knew it, that you loved what you did.
Well, one of the stories that I want us to get out in public really is your story, but you were about 14 years old, and you came down to the courthouse to visit, and my secretary, Carolyn, had something that she needed to take to Judge Johnson's office. He was still a district judge at that time.
Well, I think maybe at that time.
Maybe he was on the circuit. I think he was.
But he was here.
But he was here. He was still in the building because we were still in the old building at that time.
That's right.
And so she asked you if you wanted to come up and maybe meet Judge Johnson. So you have to tell the story from there.
So Carolyn, your assistant, took me up to Judge Johnson's chambers to deliver a file or papers or something, and asked Judge Johnson's secretary if he was in and if he would meet me. And his assistant came back and said, yes, Judge Johnson said he will meet Emily. And so I went over to the door to his chambers, and I spoke to him. I had no idea who he was. And in just our general pleasantries, I noticed he had a grandfather clock. And so I said, I like your clock. And he said, I made it. And I said, you made that clock? How do you make a whole clock? And he said, well, come in and I'll tell you. And he brought me into his chambers, and he turned to Carolyn and said, you can leave. And she left, and I went in and just visited with him. He asked me what I wanted to be when I grew up. I told him I wanted to be a lawyer. And he said, that's a fine profession. And told me about his woodworking shop in his home, where he did a lot of woodworking, and told me how he made a clock. And he walked me to the door after a little while, and I remember he opened the door, and Carolyn was sitting there, and she was sort of on the edge of her seat. And she turned around and she said, are you okay? And I said, I'm fine. And we came back, and you and Judge Carroll were actually talking in your office. And you said, well, where have you been? You've been gone for a while. And Carolyn said, Emily was just in Judge Johnson's chambers by herself.
By herself.
For about 20 minutes. And Judge Carroll said, I wouldn't want to be in Judge Johnson's chambers by myself for 20 minutes.
No lawyer would.
And I just didn't have any idea. And I remember we got home that night and you told Mom, guess what happened at work? Emily met Judge Johnson. And with her reaction being as excited as it was, I thought, who is this person?
So you were destined to live here. Interestingly enough, a couple of days later, I happened to get on the elevator when Judge Johnson was on the elevator. And he said, well, thank you for letting her come up. She is a delightful young lady. So he was impressed with you.
Well, that's nice to hear. So yes, it was like a homecoming to me. And I remember when you were practicing law, I thought, why would you want to be a lawyer? All he does is work and read papers.
That's right.
And then you came on the bench and it was just, everything was interesting. You obviously loved your job and
Still do.
and was happy, and I get that now, obviously. I loved practicing law as well, but being here, we give new meaning to the word, or to the term court family, for
Yes,
sure.
indeed it does.
So, well, thank you for
Thank you.
recounting your story for everyone. I've heard them for years, and they need to be told and preserved so that they're not lost to history.
Well, I hope
time.
people don't find this too boring to look at.
Hopefully not, but
Hopefully not.
there's always something interesting.
Well, thank you, Chief.
Thank you, Judge Coody. It's been a pleasure.